If you are thinking about getting married, you may wish to consider whether a premarital agreement is right for you. A premarital agreement is an agreement between prospective spouses that is made in contemplation of marriage and will become effective upon marriage. In North Carolina, premarital agreements are governed by the Uniform Premarital Agreement Act found in Chapter 52B of the North Carolina General Statutes. Premarital agreements must be in writing and signed by both parties. You and your prospective spouse may contract with respect to any rights you may have in the property of the other and how your property will be distributed in the event you separate. Without a premarital agreement, any property you or your spouse acquires from the date of your marriage to the date of your separation, with the exception of inheritances and gifts from third parties, will be considered marital property and subject to equitable distribution. With a premarital agreement, you and your fiancé can decide ahead of time what property will be considered marital and what property will remain the separate property of each of you. Furthermore, with people now getting married for the first time later in life, they likely have more assets to protect. A premarital agreement can be a good way to ensure that the assets you have accumulated prior to marriage remain your separate property. For example, if you have a 401k or other retirement account, absent a premarital agreement, once you get married, any contributions you make to the account, as well as any gains on those contributions, will be considered marital property. With a premarital agreement, you can provide that the retirement account will remain your separate property, regardless of any contributions made during the marriage. In addition, once married, spouses acquire various rights in the property of the other spouse simply because they are married. Some of those rights include inheritance rights, such as the right to take an elective share of the other spouse's estate in the event of his or her death. If you have children from a prior relationship, you may wish to consider a premarital agreement to ensure that you have the ability to leave your estate to your children in the event of your death. Absent a premarital agreement, your new spouse may have the right to take a percentage share of your estate, despite what your will may provide. With that said, entering into a premarital agreement does not necessarily mean that you want your new spouse to have nothing in the event of your death. Your premarital agreement can provide that each of you is free to leave your property to the other spouse in your will if you wish to do so. A premarital agreement can also address whether you or your spouse will be entitled to receive alimony. And you may also contract with respect to any other matter that is not in violation of public policy. Premarital agreements, however, cannot address issues related to child custody or child support.